All right, everybody. Welcome back to another edition of the Teardown. Although this is a very unique edition and the start of something.
That's an understatement.
Yeah.
Unique is that's a soft way to say it.
We are, this is November 30th as we're recording this, on the eve of one of the biggest stories in NASCAR history, the NASCAR trial of the century. And we're going to be.
Can we just say the trial of history? Like in the NASCAR history, this is the trial.
Yeah.
This is not even the trial of the century. This is the biggest trial in NASCAR history. And that is not an exaggeration in any way, shape, or form.
Well, that's the scene. So my name is Jeff Gluck. I'm along with Jordan Bianchi. We are two motorsports writers for The Athletic, which is a sports website for those who don't know. And I'm saying this in basic terms because I imagine that we might have some people checking this out for the first time. There might be people that aren't used to, they don't know what the teardown is. They don't know, they don't watch NASCAR races, but they are here because they heard about this Michael Jordan suing NASCAR, what's going on in federal court, all this stuff. And so this is going to be sort of an intro setup piece to the weeks to come. We think weeks, unless there's some sort of settlement in the middle of the trial. But here on Sunday night as we record this, I've flown to Charlotte, North Carolina. And we are here in the Annex Dirty Mo Studios, which is my hotel room, a few blocks from the courthouse, where we will be coming to you with daily podcasts after each night after the weekdays of the trial. The trial is expected to last 10 to 12 days, I guess, plus the jury deliberations. So we don't know how long we'll be here, Jordan. I don't have a return flight home.
You're not moving in with me. I refuse. That is not happening. You're not. There's no way, shape, or form you are ever coming to live with me for any length of time.
What is the maximum stay that legally you can stay in a hotel before they kick you out? I don't know.
Is there? I don't think there is one. Is there?
Well, you can't just live in a hotel.
They're going to take your money. Like if you're going to say I'd like to rent a room for 6 months, they're going to be like, great, here you go.
Okay. Well, that's a legal question for another time, but
it's a good thing we talk to a lawyer later.
Yeah, many legal questions now, and so listen, there's a lot of even for the NASCAR fans who have been following this for the last 2 years and the charter negotiations and all this stuff. There's so much to sort through, and I think a lot of fans have gotten confused by all the various motions and the rulings and the preliminary injunctions and all that stuff. So we just want to kind of set the scene here for what's to come. Obviously, we'll be diving into more specifics each day of the trial, but in terms of what is going on, why this is happening, Jordan, let's get into it, shall we?
Yeah, let's do it. A lot to break down. I mean, this goes back, people are going to say that the lawsuit got filed a year ago, October 2024, and that's correct. But this actually stems much further than that. This goes back to the charter negotiations, I would say, that began 3 years ago, in the spring of 2022. For those who don't know, the charter agreement in NASCAR is basically like owning a franchise, but except they're not permanent in NASCAR. It's kind of it's a system in place that goes for 7 years currently. The negotiation on the last contract, which was for 7 years, began in spring 2022, and it's fair to say those negotiations were contentious, and there was a lot of hurt feelings. And going into it, the team owners really were adamant, we want permanent charters. We don't want to have to renegotiate this system every X number of years. We want this to be infinite going forward. It'll help the business. It'll give us stability. It'll help grow the sport. It'll do everything nothing but positive from the team perspective. NASCAR has been very adamant that is not happening. We are not interested in doing permanent charters. We've never really been a sport that operates like a stick and ball sport. We begrudgingly gave you guys charters in 2016 because we wanted to help you guys, but it was never meant to be a permanent thing. And so going into negotiations, these were the two sides. Teams wanted permanent charters. NASCAR didn't want to give permanent charters, and all the back and forth always came back to permanent charters, Jeff.
So it's interesting because, from the team standpoint, why do they want permanent charters? Well, they don't want to be in a situation where two of the teams right now find themselves in, where if they disagree on a negotiation or whatever, they lose their charters if they don't sign the agreement. And these charters are worth $40 to $50 million on the low end.
The lowest charter, the lowest charter that just got sold, which is actually the lowest rated charter, if you will, $45 million. And that is the lowest rated charter. Some of the bigger teams access, people tell you, close to $100 million, if not more.
Yeah, because the higher your charter is in terms of your finish for the points,
Performance and stuff. Yep.
The history, that gets weighed into how much you get paid. So if you're one of the top, a charter from a top team like a Hendrick Motorsports or Joe Gibbs Racing, that's worth tons of money. And it wasn't that long ago that these charters were worth only $1, $2, $3 million. And even people were like scoffing at that. Like, what? Now they've skyrocketed, but the teams believe that they're still undervalued because if they were permanent, they could bring in even more investors and they could grow. It would bring an influx of cash into the sport that would help everybody from their standpoint. But yeah, go ahead.
I was just gonna say, so as part of this and this negotiation, and this went on for beginning in 2022 up through 2024 September. And all throughout this, there was some headway that was made on some things, but ultimately it came down to teams want permanent charters. NASCAR said no,
and they also wanted more money.
They did want more money, but I mean, but at the end of the day, the big issue at the end of the day was permanent charters, and that was the big thing. And you're going to hear that a lot throughout this. Is about charters, charter value, being permanency, that kind of thing. This negotiation to extend the charter agreement went on. It was contentious at times. September of 2024, NASCAR made a take it or leave it offer to the teams after years of negotiations and basically said, here's our final offer. You sign this or else. And the or else was, we're going to yank the charter agreement and the charter agreement's going to go away and you guys are going to be out and we're going to go back to how we used to do it. And all of this stability that these charters provide and revenue and et cetera, that is going away. Here's your opportunity. Sign the charter. 13 teams signed the charter. 2 teams did not. Front Row Motorsports, 2311 Racing, and those are the 2 teams that have filed lawsuit against NASCAR.
So 2311 is a 5-year-old organization co-owned by Michael Jordan, the NBA legend, and 3-time Daytona 500 winner Denny Hamlin. Front Row Motorsports is a smaller team in comparison to the powerhouse, but owned by a very successful fast food franchise owner and Bob Jenkins. I think people were a little bit surprised that Bob Jenkins went along with this originally, but he has been along for the whole thing. I think people feel like 2311 is sort of leading the charge certainly on this, but he's very much a willing participant and when there's been times where he could have gone the other way, he's stuck with them. So,
and there have been times, and it's documented in the court filings, and we have read that where NASCAR thought that Bob was going to leave the lawsuit, and there's been a few of those instances, and it has not happened. Having conversations with Bob, like he has laid it out of what he believes in and why he's doing this, and he is in a lot of respects kind of the embodiment of that NASCAR owner who's the middle class, if you will, and who isn't going to win a bunch of races and isn't going to contend for a championship, but is doing this because he loves motorsports, loves racing, wants to be in it, is even okay maybe even losing money to some degree, but does is also feels like he gets nickeled and dimed a lot and that kind of thing. Now that's his stance. Now you may disagree with that, and there's other people who tell you differently in how you run a race team, but that's his stance. And so his frustration is like, I'm okay spending money. I understand I may lose money, but I don't want to lose as much money as I have because there's a way to maybe minimize this better. There's a better business model out there that we can all have and for the betterment of the sport as a whole.
So these 2 teams decided to file suit, and in the interest of getting to where we are today and not rehashing every single thing that's happened along the way, preliminary injunction hearings and appeals court stuff.
So many hearings.
The bottom line is, right now, these 2 organizations with 3 cars each do not have charters. They have lost their charters in the eyes of the courts because they did not sign the charter agreement. They briefly had a preliminary injunction to race with charters, or with the benefits of the charters, and then that was reversed. So they do not have charters right now. Could they get them back? That's a little bit a topic of debate because some people feel that they can only get them back through the settlement because the judge wouldn't award as part of an antitrust situation, a permanent contract with somebody. But what I guess let's talk about what do they want aside from just permanent charters or getting their charters back. What are these teams going for right now? Do we know?
Well, one is permanent charters, and from conversations we've had with people in the industry, it seems like that is kind of an area where NASCAR is willing to kind of go now.
Well, you've already reported that was part of settlement talks, so they could have. If that's all they wanted, they didn't need to be here on the eve of the trial. So they must want something else.
Yeah, there's also who's going to cover the trial costs. There's other things. And the trial costs, by the way, are very expensive. We're talking upwards of 9 figures when you combine everything, if not more than that. There's also, there's revenue streams. Can teams get more additional revenue? There's governance in terms of rules. NASCAR, in terms of if NASCAR pushes a new rule out there and it's going to cost X amount of dollars, should the teams have a say and saying, hey, that's not something we want to go along with. We're not okay doing this because it's too expensive and it doesn't make sense. So there's all sorts of things like that. But at the end of the day, the two big things I think you're going to hear a lot about is revenues and charters and permanent charters.
Now, originally NASCAR countersued the teams, and that was thrown out. And so that's not going to be part of this trial at all. Whether the teams colluded with other teams, all the stuff during the negotiations, the negotiations themselves, I think, are not part of this. I think I'm oversimplifying, but they're not part of this. What is at stake here is the Sherman Antitrust Act. Originally, the teams were going to be trying to pursue two claims, Section 1 and Section 2. Section 1 they threw out. They said we're not going to do that anymore. They dropped it. It wasn't thrown out by the judge. Because what happened was, and we're going to bring our legal expert on a second to say this in a lot better terms, but from I think oversimplifying it, originally they needed to prove that NASCAR was a monopoly in premier stock car racing, and Section 2 that they abused that power illegally. Well, in ruling what the marketplace is for this case, not all of motorsports, it's just about premier stock car racing. That's the market that this is being discussed. And the judge already said NASCAR does have a monopoly in that. Mm-hmm. So now what this trial is about, essentially, again, from my understanding, oversimplifying it, is yes, NASCAR has a monopoly. Have they abused that power illegally to hurt the teams financially? Is that fair? Does that sound about right?
And NASCAR will say to you is we are giving the teams more money than we've ever gave them before. They got a bigger piece of the media rights deal that was just completed. They are earning more percentage-wise than they ever had before. So if we have a monopoly, how can we have a monopoly when we're actually giving more than we've ever gave?
All right. So we have a friend of ours here who's going to come on for a part of the show. Shannon McMinimee is somebody I met back when I was doing my own independent website. She was one of my Patreon patrons. Later, she's a big Dirty Mo Media fan, and she went to the Dirty Mo Ultimate Fan Experience thing. Do you remember when they had that suite at Bristol a few years? So she's a major NASCAR fan. However, she's also a super sharp attorney. She has over 20 years of experience being an attorney, mostly in the education and civil rights areas in Washington State. She has argued in the Supreme Court, defended the Seattle school district. And during this process, because I've known her for a while, she's been just willingly and freely sharing all of her insight through this entire lawsuit and making predictions and helping me explain on the podcaster stories what's going on. She's sort of been my secret weapon, I would say. And I think she's probably been accurate, I was going to say 95% of the time, but it's probably underselling it. She's been saying, this is what's going to happen. This is why they're doing this. And it's been super helpful. So given that she's a big Dirty Mo Media fan as well, I thought we could have her come on here and help us and maybe some other podcast appearances as well. But at least this first episode. So let's go ahead and bring in Shannon now. Shannon, how are you doing out there in Washington State?
Well, happy Sunday. I am riveted. Obviously, you mentioned that this was the trial of the century, or maybe the trial for NASCAR. I think it is a trial of the century for sports. Separate from it being NASCAR, it's obviously the biggest litigation that will ever happen in NASCAR. I'm even saying in the future, NASCAR will never have a case as big as this. And it is definitely a case that is going to garner attention outside of the NASCAR bubble. I do want to say I did not actually argue at the Supreme Court. I wrote part of the brief and was there at the Supreme Court, but I did not make the argument myself. I wrote a very nerdy brief on standing, but sadly I did not prevail on that particular argument. But I have very much enjoyed following this along ever since the two teams did not sign the charter agreement, because one of the things that was required in signing that charter agreement was to waive the potential of pursuing antitrust claims. And once that came out, I knew that this is where we would end up, because NASCAR finally had a team owner in 2311 who had experience in owning within a different league, Michael Jordan and Curtis Polk, and their experience from the NBA, and had connections from that to the highest level of attorneys in the country that do this type of antitrust litigation. And of course, then NASCAR, in turn, hired the next best person or an equally good person to defend them. And since Curtis Polk was named personally in the now dismissed countersuit, he also got himself a very good attorney. So from a legal perspective, it's not terribly often that you get to see the best lawyers in a particular field go at it in federal court with two clients that have what appears to be a relatively unlimited budget for litigation.
Is this like catnip to you? This is like all of your favorite things. You got like NASCAR, legal, sports. Yes. I mean, like lawsuits. I mean, this 100%. Is like your. This 100%. Is like this is better than Thanksgiving.
Like, I have had to tell my friends to tell me do not go to Charlotte and watch this in person. That's not a good choice.
You can book a flight. Come out and join us.
Well, I did have a case set for hearing this week that got delayed, but I do have 1 day of mediation. But when I don't think the case is going to go longer than 10 to 12 days. I really do think Jeff will be home for Christmas, so the Gluck girls will get to see their dad. And also, I don't foresee any federal judge, particularly Judge Bell, who seems to be running a very tight courthouse, wanting to ask a jury to stay up until the eve of Christmas.
Judge Bell is fantastic, by the way. Like, he has got a sharp, biting wit. And he doesn't take any crap from anybody in the court. And he will, I mean, these are two well-known lawyers who've done all sorts of cases. It doesn't matter to him. And he has no problem like saying these little quips that kind of puts them in place. It's fantastic to watch.
I will say that one of the joys of being a federal district court judge is you have a lifetime appointment. And you have law clerks who are either career attorneys or a mix of career attorneys and recent law school graduates who are the best of the best, doing your legal research and first drafts for you. So you have the opportunity to both really dig into something and be quippy. And I will credit at the second to last hearing, not the summary judgment hearing, but the hearing prior to that, you could tell that Judge Bell was fed up and was tired of the shenanigans that both Jeffrey Kessler, who represents the teams, and Christopher Yates, who represents NASCAR, bitter enemies who fight these types of cases against each other on a regular basis, started taking personal swipes. And Judge Bell was like, you may do this now, but I assure you it will not happen in front of a jury. And I did see a shift in how Jeffrey Kessler presented at the summary judgment argument. He didn't take those swipes at Yates, but he found a way to be humorous in a way that I think he was aiming to connect with Judge Bell, like the comment about Charlotte deserves a Major League Baseball team. So I will appreciate that definitely they're having to think on their feet and adjust their presentation to a district court judge who's made it very clear since he got the case, when the judge who had the case initially went senior status and therefore got a lighter schedule, that this case was going to trial on December 1st. He was not going to mess around with discovery motions, and everybody better be coming ready to go, and also fully prepared for the outcome to be whatever he thinks is appropriate at the end if the jury rules in favor of the teams. And so all this talk about permanent charters could go out the window, because ultimately he gets to set the remedy if the teams prevail.
Yeah, and real quick, and he has made it known, two things you said there is, one, he has made it very clear multiple times throughout all of these hearings, I'm going to decide what the settlement's going to be if it gets to that point. Not you guys. I'm going to decide. And he has made it very clear that's his decision. And two, it's been interesting, and you know this obviously more than I would. Have you been in a situation where a judge has repeatedly told both parties, settle? Because this has happened a lot, and to the point where it just doesn't seem like he's trying to nudge us along and what are we doing here kind of thing. It's like you need to settle this, because if you don't settle this, I'm going to settle it, and you're not going to like it.
I definitely see the theme that federal judges often remind litigants to keep my calendar clear and don't waste my time with a case that should settle. This case is unique because the jury is going to decide if NASCAR violated the Sherman Act, but it's the judge who sets the remedies if the jury makes that decision. And that's not the case in most civil matters. In most civil matters, it's usually just money or particular things, and the jury makes an award, the judgment, at the end. And that's what the parties live with. And in this case, it's kind of twofold. You convince the jury if you have to the teams will have the burden of proof to establish that a violation of the Sherman Act occurred. And then it goes to the judge to come up with remedies. And I think he has forecasted very clearly that as much as the teams and NASCAR have talked about this in relation to the last set of charter negotiations, he sees that even the existence of the current charter system could be viewed as an unfair restraint on trade. And he's looking at things that could be as broad as making the France family divest ISC and spin that off from NASCAR as a separate entity again, changing the system for purchasing via the next-gen car so that NASCAR is not the sole venue for which those cars can be used or who controls who sells those parts. So I think he's tried to make clear to the teams that and NASCAR, the ultimate outcome of this case is not a binary charter, no charter outcome. It is what he thinks is necessary to ensure that if NASCAR has been found to be abusing their power as the monopoly in premier stock car racing, using the definition that NASCAR gave to him, which I think is super important when we get down to talking about potential for appeal, that what the remedy is not necessarily what the teams and NASCAR had even been negotiating about, beyond, of course, monetary damages and the potential for those to be treble damages here in this instance, which is a prevailing party would be entitled to 3 times their damages and the recovery of attorney's fees. You've talked about trial costs. This is very expensive litigation, not only because of the level and depth of litigation where there's been so much motions practice, but also it's been condensed into about a year and a couple of months, which is a really fast time to do this amount of work on a case. So presumably both sides have had very large teams doing the discovery productions, reviewing things, writing briefs, drafting. So really expensive on that attorney's fees side of things, which also is already in play because of the dismissal of the NASCAR case against Curtis Polk and the teams, as well as the summary judgment decisions that went in the team's favor. So it's already a big hot mess, and it only has the potential to get messier if the parties don't come to a resolution themselves.
So can you clean up? You were listening before when I was, bumbling my way through trying to say what the law is here. Mm-hmm. What does 2311 and Front Row have to prove that NASCAR did in this case? Can you, in the simplest form, for not saying our listeners can't understand, but it is a complicated matter, this antitrust stuff. So can you distill it down for us? What do they have to show?
You did a great job in providing the basic framework of it, which is the court has already determined that NASCAR has a monopoly according to its own definition of what premier stock car racing is. And the question that's going to be before the jury is, does NASCAR use that monopoly position to put unfair restraints and illegal restraints on trade and use that power in a way that is unlawful? So having to prove that NASCAR's monopoly no longer on the table, and that this is about the top level of racing in the United States, and that's defined by the National NASCAR Touring Series, already resolved. The judge chose to use the definition that NASCAR had put in its counterclaim, which I thought was a very smart move on his part, which is, hey, this is what you told me, the universe you told me I was working in. and I'm going to adopt your definition of the universe. I think that was a smart choice for Judge Bell, because should the matter end up on appeal, that's one of those decisions that an appeal court will look at for the first time under a standard called de novo. And the fact that he chose to use the definition that NASCAR put forward to him goes in favor of that decision being held to be appropriate. So, big question already resolved before trial. I also think the dismissal of the case against the teams and Curtis Polk takes a lot of the back and forth about the actual who said what when, and did somebody think that a race was boring 5 years ago? Like, all of that is really not important. What is important is, has NASCAR used its position to unfairly gain a benefit and deny economic benefits to other players in the market, in this instance, the teams?
And the burden of proof is on the teams to prove this, correct?
Correct, but it is not at all what you have learned through watching Law and Order. So it is.
I don't watch Law and Order. It's okay.
Of
That's
the
an old people
evidence,
show.
not beyond a reasonable doubt. So I would love to come up with a way to explain this that is not the way that every attorney who's ever done a civil case has done it, but this is the best analogy, which is you imagine the scales of justice, which, you know, has the the scales and Lady Justice there. Imagine two piles of pebbles, and preponderance of the evidence means that a feather is put on top of one pile that makes you tilt a little bit more into the this is more likely than not what occurred. So it's
Can I just be honest? You look like a teapot when you do that. It makes me
Thank
like
you.
that
Well,
song.
I'm
Like,
to do
here's a
my
little
best
teapot.
Scales of justice, but it does come off like a teapot because you're just tipping the balance of the scales, and it just has to be a feather. So some people do that. You put one more pebble on, it leans this way. A lot of times lawyers use the feather analogy. I can assure you that when it comes time for closing argument, somebody's going to do the scales of justice, preponderance of the evidence, tip, hand gesture. That's going to be exactly like my little teapot here.
We need like a bingo board. We should create a bingo board with all of these things that you're talking about. And like, we can like, I'll be in court and I'll just be like, oh, bingo.
Hearsay, objections that are going to be common. I think there's definitely some bingo squares to be had.
Yeah. Oh, Kessler's going to play. Kessler's definitely going to be playing to the Charlotte crowd. He's already did that, as you said. Like, you talked about how Charlotte deserves a Major League Baseball team. He is, I mean, just watching him in action, because he's so noted, it's been fascinating to watch. But there, you can see him how he's just trying to like, kind of like, hey, I'm one of you guys. Like, I love you. I love Charlotte.
Yeah. The least surprise for me in this whole thing is that Michael Jordan's going to be at counsel table, right? I thought it was a mistake for NASCAR to present that motion of pick one person to represent each corporation, and it was really aimed at 2311. Because again, everybody seems to forget that FRM is here too, and I was not at all surprised that FRM came here, because Bob, the owner, likes to view himself as a bit of a maverick, and you know, he's deeply involved in franchise law. That's his bread and butter, and so he knows what it's like to be a franchisee in a system, and what percentage of revenue he gets as a franchise holder, as opposed to this sport where all they have is this charter that could go away and no guarantee of money. So I actually thought he was probably the most likely person to join in this because of his background with Yum Foods and being a franchisee.
So let me ask you this. How surprised are you, or not, that we're actually at this point? I think there was I just sort of, it's surreal to me, because I thought all along, well, they'll settle, but it's not really going to get to this point. Are you surprised that we're here, or can you see that, yeah, this was a likely outcome?
I'm surprised that we're here, given the conversations that were happening the last week of the season, right? It seemed like NASCAR really wanted to wrap up this case before the playoffs came.
There was a press release written, I believe.
Yeah. And Jordan might have been giving out some really entertaining stories, and might have had sources that told him a lot about what was going on in settlement talks, which was stunning to me. Like, this never happens. And I think Jeff can tell you, Jordan, I was like, what is going on? That was the boldest thing I've ever seen, because it was about trying to get to where you want in settlement negotiations by making the discussions public, which is rarely going to happen. And there's probably agreements to mediate that have confidentiality clauses and all of these things, but to make it as public as it was a big risk for NASCAR, because if they didn't get to the end conclusion that they wanted by that championship, to me, that was the no-go point, where if they didn't resolve it before that weekend, it was more likely than not we would be going to trial.
Yeah,
and I
there
think
was also
part of it is that the teams in NASCAR and I see this case very differently. NASCAR sees this as a contract case, right? Where it has the contract, the charter agreement, and that this case is very much about the negotiations of the last charter agreement, and you can't use failed negotiations to create an antitrust claim. The teams have argued it's much broader. It's about the power that NASCAR holds. It's about the vertical integration, i.e. control of the market that NASCAR has, and that the charter system is simply being used as a tool to allow for NASCAR to continue to get the lion's share of the money, and for the France family to get the lion's share of the money, and that it's bigger than just this last set of contract negotiations. And you can definitely see that from both sides' trial exhibits and what each side has listed and who the witnesses are, that NASCAR sees this about being really focused on the last round of negotiations, and the teams view this as being a series of events that led up to sign this by X amount of time and you have to waive your antitrust claims. So I think it'll be interesting to see how the jury reacts to those stories, and we'll start getting our first indication on how jurors are going to respond to each side's story on Monday during jury selection.
We are at this point now, and you talk about reporting about the settlement and everything, and you're accurate, and like that was kind of felt like the line in the sand of like, if the settlement was going to happen, it was going to probably be around there because of the timing. A lot of things, the holiday was coming up. There's also some key motions that have come out kind of around that as well. Which, and correct me if I'm wrong, but like from the people I've spoken with who were involved in this, they're like, this kind of like kind of emboldens 2311 in Front Row a little bit of like these motions of these key motions have gone in our favor, and it was like maybe we don't. Why are we even talking settlement? Like we feel like and that's part of it. So
I mean, I definitely think Judge Bell hurried up his decision to dismiss NASCAR's claim that week. Is he going to say it's because he read your reporting or his clerks read your reporting? No, but I think he probably saw that as an opportunity to shove a little harder to get the settlement done.
Yeah. And so here's a question for you then. Is a settlement can happen at any time. It can happen. It could happen today. It could happen tomorrow. We don't know. There have been some people that said to me, hey, maybe day one, maybe day two, you walk into court and you're like, damn, this is real. This is now actually happening. And then it like kind of slaps you in the face of like, whoa, do we really want to go down this road? Do you think we hit that moment, or are we at the point where like, no, we're all in, the chips are in the middle of the table, this thing's going the duration?
I think there are 2 points that are going to happen over the course of the case where there would be potential for resolution short of tonight or first thing tomorrow morning, right? I've told Jeff all along that I saw that if this was going to be an eve of court, day before trial settlement, it would have happened on Wednesday, given the Thanksgiving holiday and just the cost of transporting everybody, including your experts, down to Charlotte.
That was what I focused on last week, by the way. That was what I was doing there during the Thanksgiving holiday. It was that.
It is possible if it is, it's part of it is also trying to figure out what is the sticking point in the settlement negotiations. And there was another big event, which was last week, and when things became unsealed from those motions, and the NASCAR fandom got a sense of the things that the NASCAR executives were saying. And to me, if I were in NASCAR shoes, I would be concerned about that leaving the bubble, right? Because right now, as much as it feels like the biggest news that's ever happened in NASCAR, and as a NASCAR fan, I think finding out that these are the things that get said about team owners generally is a big surprise. But it's been in this bubble. And if you've not been in the NASCAR fandom and you're not deeply interested in coverage of NASCAR, you probably don't know. But if you go to trial next week and suddenly the reporting is Michael Jordan is litigating against NASCAR, who says these terrible things about the people who are team owners in NASCAR. So there's that concern on NASCAR's part of, they have to continue to maintain relationships outside the sport. They have to encourage people to want to be owners in the sport. They have sponsorship relationships to maintain. So maybe the fear of the type of feedback they got from their fans last weekend going bigger might encourage them to settle over the weekend. I think the next realistic point where there might be potential for settlement is after jury selection, when both sides kind of have a sense of who their 6 jurors are going to be. And then the next point would be after NASCAR, after the teams rest their case and before NASCAR puts on their case. I can assure you they will file what's called a halftime motion, where they say they should prevail as a matter of law. Those are rarely granted, but that would probably be the next point where, okay, we've seen all of the evidence that the teams have. Do we keep going or do we try and settle this? And then from the team's perspective, you've now given your best case. Yes, you have an opportunity to do rebuttal at the end, but based on what you've presented, are you confident enough to roll the dice, take this to the jury, and hope that you can get 6 people to rule in your favor?
Shannon, one thing I'm wondering, you referenced the text messages that came out, the communications. There's been emails that got unsealed as part of this. What are the odds that there's more explosive stuff to come that we have not seen yet that will be coming out during this trial?
I think there's likely some things that will get as much of an emotional reaction, though it's going to be a little bit different. And this is where NASCAR has to be really careful in jury selection, because they don't want to, right now, the text messages where Richard Childress is being called, redneck, you take him outside and beat him up, are not coming in. The court has ruled that those are more prejudicial than of any evidentiary value, so they're not coming in. But if you start probing the jury about potential jury, so you have your group of people who might be on this jury, and you're trying to find out what they know about the case, and somebody raises their hand and says, I know that you all called my guy Richard Childress a dumb redneck. Like, now you've told the entire jury pool about this. So your effort to get those restricted and not in the conscience of the jury kind of goes out the window. So you have to be really thoughtful in how you pursue voir dire. I wish I could pull off a Benoit Blanc Southern aristocratic accent and call it voir dire. But voir dire, the process of asking questions of a potential jury pool to find out what they know about the case and if they can be impartial and fair, you have to be really careful to start telling your story, right? You have a 10-point story that is your best version of events that you want the jury at the end of the day to resonate, to have them believe your story. But you also don't want to, in finding out what people already know, make the whole group aware of something you've already gotten thrown out because it could be potentially prejudicial to you. So I think it's going to be a tough dance for NASCAR to elicit who knows about the case, what they know about the case, and how they feel about the case without tainting the jury pool as a whole, right? Like, foreseeably, can you have somebody who, like, I'm a NASCAR fan, hate Denny Hamlin, think I can be fair in this jury? Okay. I don't necessarily think that person gets excluded. I think they get asked some questions like, do you hate Denny Hamlin as a driver, as a human being? Could you give him a fair shot? And same thing for Michael Jordan. But if you tell me that you have been closely following this case, if you've read all the news coverage of it, if you're listening to this podcast tonight, you are probably not going to be allowed to be on the jury for cause. Because again, there's 2 ways to prevent people from being on a jury: a for cause challenge and a preemptory challenge. And each side only gets 3 preemptory challenges. So you're going to try and get some of the people you don't want on your jury out on cause. And you're not picking a jury. You're picking who you don't want on the jury, either because you think they're going to be an opinion leader against you, or because you think they are unlikely to connect with your version of events.
It would be hilarious if the jury pool was like Richard Petty and like some other like crew chiefs or like crew guys or some other people in the sport. They like live in the area and they just got randomly picked for this federal case.
I mean, they probably sent out a really large summons, right?
I know.
You have to pull a big pool.
Yeah.
And you're not necessarily going to eliminate people who have some connection to NASCAR. Like, obviously, if you are an executive in NASCAR, you're going to get tossed for cause. If you work for Front Row, you're not going to be seated on the jury. But if you sell concessions at Charlotte Motor Speedway, or you do PR consulting for a couple of teams, I don't necessarily see that you're disqualified in this case. I think it's really hard to find a jury in this district of North Carolina who doesn't know anything about NASCAR doesn't know who Michael Jordan is.
I wanted to follow up on Jeff's question about some of the stuff that has come out, and then obviously there's potential for more coming out, right? What we really haven't seen necessarily is any of the bombastic stuff that NASCAR's present, from the NASCAR thing. And as someone explained it to me, and is that they could be saving this. Like it's what you want to maybe win the court of public opinion, and they're losing that right now. There's no doubt about that. But at the end of the day, you want to win this case. And so maybe you save your silver bullets, and there's certainly, as it has been explained to me, is like there are certainly messages on the other side that are equally as inflammatory. So is that something where you could see like NASCAR be saving this for the trial?
I wouldn't say you wouldn't have saved it for a trial and filed the summary judgment motion, right? Because when you are putting your best case forward to have this case never go to trial. So you should be putting your best evidence forward in the summary judgment motion. Because remember, they asked for the entire case to be dismissed on summary judgment and lost that. So that being said, I think there's a real difference in leaning in on commentary among the team ownership and commentary among NASCAR executives, and how much it's going to be considered in the ultimate question of, has NASCAR, through its executive team and Jim France as a human being in his role at NASCAR, engaged in illegal activities as it relates to their monopoly position? So it has a different meaning. Like an email where it really doesn't matter that Michael Jordan's CFO thinks Denny Hamlin's a bad businessman. Okay, that doesn't really impact what's going on within the sport, and if NASCAR is using its position of power in the sport to restrain trade. When you see those communications among the NASCAR executives that are like very reactionary and very fearful of competition, like I would have never expected that the reaction that came to SRX as a series, right? This, for people who are not in the NASCAR bubble, a weekday Saturday series that had retired drivers, some current drivers, local track drivers, not in any way, shape, or form the size or scope of a NASCAR race, was something that caused a lot of fear within the NASCAR executives as far as competition. So much so that I think that some of the things that fans would say have been huge positives for the sport over the last couple of years, having a race at North Wilkesboro, having a race at Bowman Gray, seem to be things that happened in reaction to some NASCAR drivers and retired NASCAR drivers and team owners competing in SRX, which doesn't even exist anymore. So I think there's, again, that definition of, NASCAR may have some emails that make Denny Hamlin or Bob Jenkins or Curtis Polk or Michael Jordan look bad, but at the same time, that doesn't have anything to do with, was there unfair restraint of trade? Now, if one of those people wrote a glowing email to NASCAR about how fair they thought the NASCAR system was, that might be a big silver bullet that would have a lot of impact, but I don't think we would be here, because obviously the teams but there's not a Perry Mason moment in litigation in the way that we think happens. I had a couple of super weird things happen, like people burst into the courtroom and want to intervene, and that does not happen, but I've had it happen to me. But very rarely do you go to trial where you don't know everything the other side has that might be harmful to you. And in fact, you prepare, and I would expect in this instance, both sides have engaged trial consultants who've done mock jury work for them, or where
they have.
You only get any benefit from that, which is very expensive, by the way, if you put on what you think is the other side's best case and you overplay what the other side has to a mock jury to know where your vulnerabilities are. So I don't think that there's some big silver bullet smoking gun that NASCAR is going to present on the stand. Obviously, they're very invested in Rick Hendrick and Roger Penske testifying to take the chance of naming them as late in the cases they did and making them be deposed before trial and all of this. So they clearly think that those are going to be strong witnesses for them. And it is unusual to name people that you are out there saying are great witnesses for you as late as they did. I can definitely say who I think will be key witnesses just from my read of the evidence, who might have potential to really impact the jury. And I think separating from the parties, obviously what Jim France has to say and whoever testifies on behalf of NASCAR's executives, what Michael Jordan, Curtis Polk, Denny Hamlin have to say. I think there's some people who are not parties to this case whose testimony is really going to matter. One person who's stood out to me is, I think, Heather Gibbs, who represented JGR in the negotiations. A lot of people are like, oh, why aren't they calling Joe Gibbs? Well, Heather, who was is the widow of Coy Gibbs, who passed away. Joe Gibbs' son, and Joe Gibbs' other son, JD, also passed away, putting Heather in the position of kind of stepping in to be the second generation in that family. She's a very successful realtor. Every time you hear about a NASCAR owner buying or selling a house, you'll probably see that Heather's the agent involved in some way or another. Wrote a really impassioned letter. And I would say it's also, but without being over the top. She wrote a very personal but also reasonable letter to the NASCAR leadership after a round of negotiations. And apparently, from reading the deposition transcript, that was not well received by Jim France. And I think that is the type of thing where Heather Gibbs does, like, she's not she doesn't work for either of the two teams that are suing. She's kind of advanced a really reasonable sounding position in her letter and is getting reamed by Jim France in a meeting about how dumb she is and or how this is the worst thing that's ever happened in the history of the sport. And I think that's where NASCAR has the potential to not come across well, especially with commentary about, oh, she's just doing this for a book deal. Don't worry, our fans don't read. I read. I like to read. So I think there's some landmines there with the freeness of their texting with people outside the organization as well as internally, where both sides know these things have been said. It could be really problematic, but I think Heather Gibbs has the potential to be a really important witness, and how the jury reacts to her will be important, in addition to the big named players. I think Roger Penske is going to be interesting because he owns his own racing league. And, what is he going to say? And how is he going to pay attention to the potential for opening up this same problem for himself as it relates to his other league?
Which has charters, and they modeled that system off of NASCAR's.
Right. And so that cuts both ways. Like, oh, okay, you did this because you as a team owner want this as the person, and you're now thinking as, oh, I'll get all this money because I own this thing. And then go ahead.
I was going to say, so you mentioned Roger and Rick, and this is something I really wanted to ask you about, is presumably they're going to get on the stand, and Rick has said this publicly, right? Like, hey, yeah, this was a brutal negotiation. This was tough, but we got a deal. It's the best deal we could get. So you have 13 team owners that signed this deal, that for whatever they saw as a reason to sign this. How do you explain then, if in either side, of why 13 guys were okay with this? They signed this deal. They may not have liked the deal, but it was a fair deal. Or at the end of the deal, it was fair enough to them that they signed it. But yet two didn't. So how do you weigh that in a courtroom?
Well, just because you are okay being within a monopoly and having unfair business practices done against you doesn't mean that there isn't a monopoly that's doing unfair business practices, right? So the fact that 13 other teams agreed, I think that if NASCAR really argues that point heavily, then you're going to get into, they agreed because they felt like they had no choice and they would lose their entire business if they didn't. And they didn't have the benefit of Michael Jordan and Michael Jordan's checkbook to cover the litigation costs for this, because I understand that Michael's fronted 2311 a lot of the legal fees. So I think that's a tricky place to go down. And a lot of the owners, when NASCAR filed its summary judgment motion and submitted declarations, there's just some standard language that you always see in declarations. And to me, I could see where the declarants, the people submitting these declarations, had made their own changes to the documents that were different language than you would see, or in weird places for the language to come across. And the majority of them were advocating for permanent charters. In fact, Richard, obviously, we're not going to see Richard Childress as a witness at this point.
It could be great, though. I would love this. It'd be fantastic.
I wonder if NASCAR asked him for that declaration before or after they told him about what they were saying about him. But I mean, in his declaration, he's like, I see the solution as permanent charters. So, and even Joe Gibbs, in his very clear, like, do not call me. If any side calls me, I'm not going to testify. And it turns out he isn't even the person who has the knowledge. That was Heather. That they risk the fact of NASCAR is such a powerful monopoly. These other entities cave to them because they know they have no other power, and they didn't have prior experience in owning sports teams or in Jenkins' experience running franchises to understand what they were agreeing to, and that what they were agreeing to was an illegal monopoly. The weird question that I've gotten a lot about this, and this relates to Rick Hendricks specifically, is how does he testify without his prior federal conviction becoming an issue?
Well,
That could be raised in court, you're saying?
even if that got
The pardon, does
yeah.
the pardon matter?
yeah.
I might have spent an overwhelming time going down this rabbit hole. Federal rules of evidence allow for admission when a witness testifies, admissions of a prior crime that was a felony that carried more than a year or more jail time, and crimes of dishonesty to be admitted so that the jury can weigh the credibility of the witness. There is an exception related to pardons if the pardon happened more than 10 years ago, but it is specific to what the pardon was granted for. Meaning, was it a pardon where they found rehabilitation, or was it a pardon where they found actual innocence? And I have started the deep dive of looking back to Bill Clinton's pardon of Richard Childress and what basis they gave.
Rick Hendrick.
I'm sorry, Rick Hendrick. So deeply thinking about Richard Childress and the whole commentary, but
I'm hoping Richard Childress is on jury pool. That would be fantastic.
That would be hysterical. He will not be. He will not be it. So going.
They couldn't strike him quick enough.
Right. No, they'd be like, he's already filed a declaration in the case, so he would be, congratulations, welcome, go away.
Don't ruin the dream, please.
If Mrs. Childress comes in, that could be wildly entertaining.
Oh, well.
But going back to Rick Hendrick, and let me say this correctly, what will matter is what was in the actual terms of Rick Hendrick's pardon and the basis that then President Clinton gave for his pardon. So I'm sure the teams, as soon as Rick Hendrick was added to the witness list, started doing the research to actually pull up the physical document where his pardon exists to identify the basis for that. And if it was done based on rehabilitation or actual innocence, that's where we'll hear the argument around if it can come in or not.
Shannon, we're almost to the end of our podcast for this intro episode. Obviously, we'd love to have you back on at times throughout this trial, but just for this week, we've talked about a lot of the specific things going on and at stake here. What are some things that people should look for as we come out of court the next few days? They read our coverage. What are some things people need to be paying attention for in this first week one or these first few days of how this is going to unfold? What's going to happen?
Sure. I think the first thing is it's important for people to understand the jury in this case is going to be 6 people with 3 alternates, not 12. And they have to have a unanimous verdict. You can agree to have a non-unanimous verdict. It almost never happens because for NASCAR, they just want one of these 6 people to come in their favor. So if both sides still had viable cases, you might see an agreement to have a non-unanimous verdict. Since NASCAR's case was dismissed on summary judgment, I foresee it being 6 people, unanimous verdict. I would expect that the jury selection is probably going to take a little bit longer than Judge Bell has budgeted for so far, but he also probably sent out jury questionnaires and has an idea of who's going to get struck for cause for things like, I own my own business. There's no such a thing as a substitute X. I'm a caregiver for my elderly parent. So I think he's already going to have gone through the people who have cause for other commitments. And there's going to be a harder look at people who might have some sort of relationship or pre-established belief related to the case. I think you guys sitting in the courtroom will have a good sense of what each side's story is going to be, in part based on the questions they ask potential jurors, because they're trying to sprinkle in what they consider to be the good points of their case and saying, how would you feel about, would you ever consider, to get a sense as to where potential jurors might have bias and might have prejudice. And then you should hear tomorrow opening statements. And it's really important to note the difference between opening statements and closing arguments. Your opening statement is not supposed to be an argument. It's supposed to be a preview of what you believe you will be able to get in as evidence and what that will tell the jury. So a lot of the things that will be talked about won't be the smoking gun. It will be the things that both sides have already admitted exists. Is the true and correct copy of the document? So you'll hear things like, you'll hear testimony from so-and-so and so-and-so talking about X, Y, and Z. You'll see documents that say X, Y, and Z. So it will really be the preview of the case overall. I think it will be interesting tomorrow to see if they let Denny Hamlin and Curtis Polk sit at trial table with Michael Jordan. And then also if they decide no, one corporate representative, who's going to be sitting next to Jim France for NASCAR? Because if you decide only one corporate representative, that applies across the board. So it'll be interesting to see who's in that NASCAR decision-making bubble. I would think if I was in Christopher Yates' shoes, I would pick Ben Kennedy or Lisa France Kennedy to help with this image of this is a family business, right? Like, I wouldn't want to have a NASCAR executive sitting there. I'd want to have multiple members of the France family to tell my story about how this is a family business. So I think that's the first thing that you're going to see is you'll get a good preview tomorrow of what both sides' 10-point story of what they think their case is and what types of jurors they may not want on the case.
Will not hold you to this. We have no idea how this is going to unfold. There's going to be a lot of twists and turns. This is a roller coaster ride over the next 10 to 12 days. But
I'm going to be the weirdo who is constantly refreshing my Twitter feed trying to figure out if you guys have taken your courtroom breaks. And I'll say that for listeners. For the rest of us who are trying to follow along by desperately looking at Twitter and what's posted on bathroom breaks, in general, I would expect that there's going to be a break around 10:15. That's a 15-minute break. These are regular trial days. Tomorrow is going to be different because it's jury selection. But on a regular trial day, I would expect a 15-minute break in the morning, hour to an hour and 5 minutes for lunch, and a 15-minute break in the afternoon as kind of the bare minimum. There might be other breaks, but those are the times where I'm going to probably start refreshing my Twitter feed to see if Jeff or Jordan have stepped out into the hallway and started typing away.
It's hard to get our phones though. Like we're on the 4th floor and we have to go down an elevator back through security, and then we have to go
there's security again.
And then there's a lockbox. Our phones are in a lockbox.
Oh wow.
So so when you walk into a courtroom, the federal courthouse, you go in and you go in the little lockbox like you would at a bank, right?
Yeah.
And so you put your phone in there and all of this stuff you can't have. And you put it in there.
You're not going to make it down on bathroom. Somebody's going to have
to. So what I'm saying is like you're not really going to have.
You're going to have to take trade-offs where on a break, one of you commits to going and getting the phone and posting something, and the other one stays in the courtroom.
Listen, we are professionals here. We have a grand plan. We are the best of the best.
I'm not getting into the grand plan.
The elite. We know what we're doing. We've got a plan, and we're going to blow everybody's coverage out of the water.
I hope you have comfy cushions because there is nothing more
okay, so in all seriousness, I have a really important... Can I bring a donut?
Yes, you can bring your cushion.
I can bring a donut?
Yes.
Okay, that is really good.
I brought the donut before back when I was the least important attorney on the team and was sitting on the bench behind you.
Those things suck. The benches are horrible.
8 to 10 hours sitting on those benches will wreck you. To this day,
100%. I'm going to literally expense a massage to my company after this thing. This is awful.
She texted me to bring a couch cushion, and then I forgot it. So I need
is there like a size limit on this, or can I bring
I would aim for donuts / nothing that like what you would have on an coach class airline.
Okay. I'm gonna go get my.
Your number one assignment for tomorrow is to make friends with the marshals, the court security officers.
Don't worry about that. I'm already working on that.
Those are generally speaking retired federal agents. Your job is to become besties with them because that
trust me, it's already started.
And it'll get your cushions in because you don't want to be wrecked come Friday.
Oh no! From day one, I've already made friends with them. They know who I am. They let me come in and hang out. Like it's fantastic. I'm already greasing the wheels. This is like making friends with the office secretary in high school. Like you know how to get the free passes so you can be late to class. It's the same thing.
This is the exact analogy.
Don't worry, I'm on this. This is my wheelhouse.
The head secretary and the court security officers are the same people.
Executive assistants, the same thing. Yes. And they know where the bodies are buried.
The judges, both the clerks, right? The law students or young lawyers or career lawyers who are going to be there. And then the judges, bailiff, and the chamber staff are also people you're not going to want to cross. You won't have as much opportunity to interact with them as you will the courthouse officers, but those are people you just, and if you see one of the attorneys make one of those people mad, know that it will come back to bite them. Don't make it. I kept telling Jeff through all of this, like, don't make a federal judge mad. And like when NASCAR's filing things on the eve of a holiday, or like the day the entire country knew that Pacer was going down for maintenance, like, don't do that. That does not make a judge happy. Don't make judges cranky. That's your first and only role. And you'll see the judge be really protective of the jury and their time. And you might just, how Judge Bell's demeanor is, if they start being snitty in front of the jury and requiring him to pull people up for sidebars, I can assure you that the attorneys will get lectures about being respectful of the jury and respectful of the jury's time. Don't be late. Do not be late. And that goes for everybody. Like, worst choice Michael Jordan could make was rolling in late, because he will get scolded.
So I'm bringing a donut. We know that. That's all. These is all great advice. But
you might want to bring donuts for the court security officers, but definitely.
I'll do that. I've done that. In college, I actually brought my professors donuts, and I bought them baseball tickets. One of them too.
Okay, so definitely consider the donuts again, but definitely bring yourself a seat cushion, because you don't want to be broken come Friday.
Okay. Good to know.
But he wants to ask you. I think he wants to ask you for your prediction.
Yeah, I'm getting. I was going to get to your prediction. What's your prediction? Yeah, what's your prediction?
Whew,
Besides lawyers getting rich.
Well, I don't know if you can get rich at this point, because you're not going to get the final bills paid in time for this year's partner distribution. So you're going to do well, but you're
getting paid at some point. You're getting paid at some point. You ain't doing this out of charity.
I really want to see how the opening statements go. And if my belief that the two sides are seeing this case really differently holds true, I'm worried for NASCAR, because if they approach this as a contract issue, they're going to miss all of these other things that Judge Bell has already indicated. If you get me to the remedy stage, these are the things I'm going to look at, which are way different than just looking at this about the charter negotiations. I think seeing how the jury reacts to Jim France testifying, to NASCAR executives testifying, to the 2311 and Front Row Motorsports principals testifying is going to be huge. And then how they react to people like Heather Gibbs, Roger Penske, Rick Hendrick are going to give us a really quick, easy sense of where this is going. I never predict what a jury is going to do, because whenever you think it's going to happen, something weird will happen. I've had to call 911 because of jurors getting in a fight before. Yeah,
see, this needs to happen.
It's like you can't predict these things, but I think we'll get a good sense as to what the rhythm of the trial is and where the fight is going to be, probably by Tuesday. And I think that if NASCAR prevails and Michael Jordan sits at counsel table and Denny Hamlin and Curtis Polk are sequestered because they're on the witness list, I expect that those will be the first two witnesses for 2311, so that they can be in the courtroom and be sitting at counsel table early in the case. So I've always thought this was a wild ride. I always thought the mistake that the teams made was pursuing the injunction under the new charter agreement instead of the one that was in place at the time they filed their lawsuit. I think I told Jeff that 27 times. Like, if they had filed and asked for an injunction to continue to enforce the existing charter agreement, I think that would have been upheld, because that would have been maintaining the status quo. I understand from a business decision that they were trying to not make the other teams mad at them, because yes, the teams are getting more money under this agreement than the last agreement. But I've always thought that there was definitely there. And the summary judgment rulings have confirmed that what I thought would be the strengths of the team's case with regards to NASCAR has a monopoly. This is the premier stock car racing league. If you want to talk about one of the quips that Jeffrey Kessler made that went over well, as opposed to the snipes that he was making at Yates in prior, that tell Michael Jordan he has to go buy put a gun to Michael Jordan's head and tell him he has to go buy an IndyCar team. You better have a really big gun. I just
yeah, really, really good.
Okay.
That was his best day in court. Kessler's best day in court, because that was the same day also the same day he had the minor league baseball.
Correct, and I really thought that. But he picked up what the judge was putting down at that last hearing.
That was the first day where you could see. I was really blown away by Kessler, and I was like, this is really impressive. Like, you can see it now, like he's got it. Because before that, you're like, oh, okay, all right, sure, I guess.
Before that, it was two heavyweight lawyers
Yeah.
duking it out in the same way they have for years without tailoring to their audience. And I think I might have tweeted after the hearing that got really spicy that I didn't think either side was picking up what Judge Bell was putting down. And then I was very pleasantly surprised after the summary judgment hearing that Kessler, and I suspect what he did is talk to other judges or talk to other attorneys who practiced before Judge Bell, or talk to other people who are more familiar with this district, to get a sense as to where he should make changes in his affect and his presentation. And he definitely understood the assignment and made changes. And I think that will also help him if he keeps that style in front of the jury. If he or Yates get back to sniping at each other, both sides will ultimately lose the jury.
Well, Shannon, thank you so much for popping on here. I know obviously you're full of knowledge, and I hope people enjoyed hearing from you. This is obviously just getting started for our listeners here. So we'll be back. I guess we'll do a live stream when we get out of court. So maybe about 6:30 p.m. each weekday night.
Early evening, yeah.
Early evening.
Eastern time, because remember,
Eastern
you do
time.
have
Eastern
Western
time.
fans.
That's right.
Early evening.
Not to exclude you Pacific time.
6:30 Eastern time. Live stream.
Some of us who are in NASCAR Siberia do feel the need to point out, like, it'll still be mid-afternoon here.
Right. So, and we'll also have daily reports, written reports on The Athletic. So check that out as well. But hopefully this at least is a tone setter, scene setter for you guys to understand what's going on. Shoot us any questions you might have in the meantime. And what's your ex name, Shannon?
My name.
Oh, just Shannon McMinimee.
I'm boring. I use my own name on almost all of my social media. So Shannon McMinimee.
That's
And
what cool
McMinimee is spelled McMinimee. Yes.
Yep,
Okay.
MC Mini Me. But I'm super excited about the opportunity to talk with this about outside my circle of friends who are probably really tired of my stream of conscious text messaging. And poor Jeff has gotten me like something's come out and I've sent him like 27 text messages and like, hi, happy Tuesday, bye. So I'm really, like I said, I think this is more than just the biggest trial in NASCAR history. I think it's definitely going to be a huge trial for sports. I think it's going to get the attention of people who don't otherwise pay attention to NASCAR because of the involvement of Michael Jordan, and because it's at the time of year where there's not a lot otherwise going on, right? We're going to be coming into December, and unless you want to watch Christmas specials or holiday specials,
No. Hard
He's
pass.
anti-Christmas.
Jordan's
he's not a fan of Christmas,
watching.
so, yeah.
The Hallmark channel is literally blocked at my place.
Okay, so if you're not
Like,
watching the Hallmark channel, and I'm sure there are people out there who are like you and Grinch-like and don't want to watch the Hallmark channel, this is going to be some high entertainment. And I think it also is going to get a lot of interest from everybody who's involved in NASCAR, from sponsors down to
that's
team
the case.
employees. And also,
this is
going to be the first chance in a long time for NASCAR, and I use that as the big bubble, not NASCAR, the entity, but the NASCAR
industry
world,
as a whole,
to see what the rest of the world perceives of NASCAR and its fans and its teams and its ownership. And is it a serious professional business, or is it a family-run institution that works on good faith values? Like, who's it going to be? What version of events are you going to accept?
All right, everybody. Thanks so much for listening, and we will talk to you next time on The Teardown. See you, everybody.